Well, of course, the breaking news, the developing news, and it's still going to develop through the afternoon. Nosiviwe Mapisa-Nqakula, the new National Assembly Speaker. That election, 199 MPs voted in favour. How many ANC MPs were voting today? 201. Did two of them not make it to the ballot box? Well, we'll try and find out. Let's get some reaction to this on this and other issues. Lawson, Naidoo, the Executive Secretary of the Council for the Advancement of the South African Constitution. Lawson, good afternoon to you. Nosiviwe Mapisa-Nqakula as the Speaker of the National Assembly, is she the right person?
Well, good afternoon, Stephen. Thank you very much. Look, I think, judging by the responses that we've heard from opposition parties, Nosiviwe Mapisa-Nqakula is going to face a tough challenge because the most important thing that a speaker has to do is to command respect from across the political parties in the House. And it seems that there's a great deal of skepticism about her ability to do so. And so she's going to have a tough job to win them over and to ensure that there's respect for the dignity of the House and that Parliament can actually conduct its constitutional mandate properly. We've seen in the past under the previous Speaker, Baleka Mbete, how the Parliament really became dysfunctional under her leadership because of these very same concerns and issues, and we certainly hope that we don't go back to those days.
The reason that we invited you to speak to us today was about the Constitutional Court rescission application, which has been brought by lawyers for former President Jacob Zuma. He's currently in a hospital, but technically under custody of correctional services after the Constitutional Court ordered that he spend time in jail for defying their earlier order that he testify at the Zondo Commission. He's launched an application to have the Constitutional Court judgment rescinded. The Constitutional Court, as I understand it, then asked various parties if international law applies to this case. You've made a submission. What are you saying?
Well, this is a submission that is made in the rescission application. I think it's really important to stress that at front. And insofar as a rescission application is concerned, it needs to be argued and decided on the narrow grounds of whether a rescission application is appropriate in these circumstances. And it seems to me that the raising of this issue, conflates the matter before the Constitutional Court. It's not an appeal against the judgment. It's a rescission application of very narrow grounds. But when it comes to these directions of the Constitutional Court regarding the applicability of international law, and in this particular case, the International Covenant on Civil and Political Rights, the Constitution is very clear that courts must consider international law when interpreting the Bill of Rights. But we argue in the submission that we've made as amicus to the court that this doesn't help Mr. Zuma's case at all and does not help his application for rescission, because the guarantees that are provided in terms of South African law are actually stronger than what the International Covenant of Civil and Political Rights provides for people detained without trial and ensuring that there is a trial and a right of appeal and so on. And we point out in our submission that this was a civil matter. It was a case of civil contempt, albeit with a criminal sanction imposed as a result of that. And therefore, the International Covenant is not applicable to the matter before the court and should not be considered.
One of the main arguments that his supporters make, they say this again and again, that he's been jailed without trial. You don't agree with that, right?
No, I mean, and the point that we make again in our submission is that it is a well-established principle of South African law of the process of civil contempt that can attract a criminal penalty. And that's exactly what happened in this matter. It was a case of civil contempt, a judgment of the Constitutional Court, where he failed to abide by a summons to appear before the State Capture Commission of Inquiry. And the courts went through a proper process of assessing that and determining that, in fact, South African law provides for the offence of civil contempt, and that the appropriate sanction in these circumstances would be a term of imprisonment. And Mr. Zuma was given the opportunity by the Constitutional Court, even though he didn't participate in the case, to make submissions to the court, and he refused to do so. And it's really too late for him to be, or his legal team to now be arguing that extraneous issues such as the International Covenant on Civil and Political Rights can somehow override the decision of the Constitutional Court.
There's a much bigger issue that might well be developing. Lawson, you'll know more about the law than I do on this. But, I mean, a rescission application is incredibly rare. A rescission application to be heard by the Constitutional Court, I would suggest, rarer still. Hardly ever happens. There's a reason for that. Their rulings are supposed to be final. You have to have finality to a dispute. Now, they're taking some time to make this decision. Now, on the one side, that's probably a good thing. You want judges on the Constitutional Court to take their time and get the decision 120% right. At the same time, though, the former president is able to apply for early release, partly because of his age, but generally because of the crime that he's committed. In other words, it's a lesser offence. He would be able to apply for early release roughly 3 3/4 months after starting his sentence. There's a risk that he would be able to apply for early release before they give a ruling.
Well, that's certainly a possibility, Stephen, especially now that these new directions were given and parties had to make their submissions by yesterday. The court will now have to apply its mind to that. And, what should have been a fairly straightforward decision by the court in terms of does the application that was brought by Mr. Zuma fall within the rules of court as regards a rescission application. Our submission in the case itself was that it does not, and it should be dismissed. The rescission application is therefore for where there are clear factual or legal errors, none of which exist in this particular case. And therefore, there does exist the possibility that judgment may be handed down after Mr. Zuma becomes eligible for parole, and indeed may even be paroled before judgment is given, which is not an ideal situation. One would expect that the Constitutional Court would be alive to those issues and to use every mechanism that's available to them to reach an early decision and to deliver a judgment to put this issue to bed once and for all.
Lawson, Naidoo, do appreciate the time. Counsel for the Advancement of the South African Constitution, thank you very much indeed.